Kurt Harris, number 5354.
We're our attorney Al Needham, bar number 5079.
All right, that's Michael Franklin, the named defendant. You represent yourself.
Yes.
Okay, welcome. Please have a seat and relax, everyone. All right, here it's plaintiff's motion for summary judgment, and Mr. Needham, you have on behalf of your client Ernest Del Casal a counter motion for summary judgment. So again, interrupt me if I have any of the facts wrong, but it's alleged that sometime in early 2014, Mr. Needham, your client Ernest Del Casal, approached Mr. Harris here, offering to sell a business known as Equal Rights for Divorced Fathers. And so as I looked at Mr. Harris, your complaint, there's numerous allegations made in there, including that Mr. Casal did not provide a password to this website for the business, and during the transition period, you alleged that the defendant, Del Casal, received funds from the business and didn't provide any accounting having to do with the funds. You further alleged that there were blogs and websites created, and on those blogs and websites there were comments made with intent to cause harm to your business and essentially defame you. And you, in the complaint, alleged that both the individual defendants continue to use this website that was supposed to be conveyed to you. And further, you allege that there was some effort to redirect, I guess, individuals, maybe even potential clients, from that Equal Rights for Divorced Fathers website, or that website you thought you were obtaining, to some other redirected website having nothing to do with the reason why you thought you should have the website in the first place. So I guess that's to get legitimate clients for the legal practice. As if that's not enough, you also allege that, I think you're alleging this has to do with Del Casal, that he follows you around the family court building without any reason and seems to be obsessed with you, frequently following you, driving past your places that you're at, including business places, regularly. So that all is contained in an amended complaint and has various causes of action that you want summary judgment on, including theft, civil conspiracy, intentional interference with business disparagement, and also defamation or defamation per se, since this does, of course, involve your profession. And you have a punitive damage claim in here as well. And so, let's see if I have this right. We had a hearing here on March 5th, and that had to do with potential restraining order activity. And as I remember what happened there was some sort of stipulation that might come about as opposed to a restraining order. But I haven't seen a stipulation come to the court's attention, so maybe we should talk about that at some point. So make a note maybe to mention that to me. But basically here, Mr. Harris says, I was supposed to get the web services. I did keep a couple guys, Boyer and caterer, who worked for me. And they had worked with Mr. Del Casal. But basically what you say is, look, I still don't have the password or the full access or complete access to the website. You bring up what you call a smear campaign, fraudulent bar complaint, following around family court, the website that's been published, which you refer to as a manifesto. And I want you to know I've seen and I've read through all the materials here that show the alleged publications and internet sites and all that. And I would just say, no doubt that the items do make comment that would, on this face, harm your professional livelihood or your profession as an attorney, I'll give you that. That's easy to tell from the paperwork. Anyway. So Mr. Needham, your part in this is, it seems like what you say to the court in your pleadings mainly is that essentially, look, it was all Mr. Franklin, who's here in court sitting next to you. But basically you say that the website where the defamatory, if defamatory statements are made, is owned by Franklin, and that your client didn't, Mr. Del Casal, didn't publish any of the statements on the website. And so basically, that's your mainline opposition. I know you have more to say. And then Mr. Franklin, for your part in it, you say, well, I deny I worked with Mr. Del Casal to do any of this. So what I think is going on, at least as a starting point here, is that the two defendants are blaming each other for what happened, it seems to me, is what it looks like from the paperwork going in. And you also have summary judgment requests yourself that you can tell me more about. So with that, Mr. Harris, I'll start with you. It's your motion for summary judgment. And I guess that if I were to just throw one thing at you to consider, and I'll stop talking, it's this. I already told you that I clearly see a lot of things that respectfully you should be concerned about as a lawyer being done. I mean, it's pretty obvious from the internet activity. To me, and as far as where we're at in court right now, it's summary judgment activity. So the question would be, I don't think the question is whether you meet your initial burden, which I think you do meet your initial burden under Wood versus Safety. We've produced a lot of evidence to show legitimate factual underpinnings to all of these causes of action. The question would be, who would the summary judgment be against? And if there's a genuine issue of material fact where the two defendants sort of blame each other, it could be that we need to still have some sort of finder of fact, namely a jury, figure out which or any of them or who did what, basically, is what I'd say. So you go ahead and tell me what you think.
Thank you so much, Your Honor. I completely understand the court's concerns. I know the burden of proof here as well, and I do understand that. I just felt as though I was somewhat compelled myself to file this motion. I do not believe there are any issues of material fact. Just a couple of things that I want to clarify to the court's summary, which is very good. I did present a stipulation or two to Mr. Needham. They've refused to sign that stipulation. I don't know why. It was a pretty generic stipulation, and I thought that we had a deal when we were here in court. But upon leaving, they would not sign that stipulation. And I did attach a copy of that stipulation, a proposed stipulation that I had sent over that was refused to be signed. And so that's where that's at.
Okay, well, maybe we can still do that. I mean, some sort of generic agreement to just have a status quo, stop whatever anybody's doing until the case is resolved is what we'd be trying to do. I think that's, as I probably said, I don't remember because that was March, and I can't remember what I did in March.
I have the minutes right here, Your Honor.
What did I say? Did I say
Well,
something
the
good?
parties are supposed to work together on a stip. And Mr. Harris sent me a stip, but it was basically having Mr. Casal admit liability. I'm like, we can't do this, and he's denying he's involved here. So but that's the problem. And then at that time, Mr. Franklin wasn't in the case. So now he is, and the evidence now shows that Mr. Casal did not create the website and doesn't own the domain, doesn't own it. So there's...
Be that as it may, would you be interested, or would you still, to avoid the potentiality of any restraining order activity?
Right, we need to work together on the language to make it where it's acceptable.
So that sounds like you're saying you would...
Yeah, we have a language problem.
Okay, so I'd like for you to do that because I think it's really something beneficial to all parties. In other words, Mr. Harris as a lawyer, of course, like any lawyer, wants to have sort of a cease and desist of the internet activity that disparages him or appears to disparage him, okay? The defendants have an interest in not aggravating damages that could potentially take place in the case.
Any
I mean,
concern is that-
And by the way, that's not to say that I've drawn any conclusions about, at the end of the day, whether you can prevail on all your claims. I'm just saying you have evidence of it here. Clearly, there's evidence of it. And, you always get into, and I don't think anybody's brought an anti-slap style motion here yet. But I mean, the First Amendment always wins the day with freedom of speech, and so we have to, at some point, consider that. But you don't have freedom of speech to defame someone. So you do have to look at what was said and analyze it. But in any event, if we get a stipulation put in place, I'd appreciate it. I know I left court in March thinking that was gonna come our way.
Yeah, and I don't think at that time Mr. Frank was in the case yet, so the question would become, who should the stipulation be directed to? My client's saying he's not involved in it, so what can he stop? He can't stop somebody he doesn't control, the website. So I don't know how to fashion it in that manner, but now Mr. Franklin's in the case, so I think the stipulation would involve Mr. Franklin, not just Mr. Casal.
Okay, all right, let's get to the,
Fair enough, Judge. But just to clarify, I did reword that stip. I sent over a second one. I think it's irrelevant as to Mr. Franklin, as to what Mr. Del Casal does or doesn't do. I don't think we have to stipulate all parties together sometimes to say I'm going to refrain from doing anything, or I'm not going to do anything I wasn't doing.
I think
So,
that it's
we're gonna
highly,
language.
I think it's highly likely I'll get a stipulation from you guys that just maintains the status quo. So let's
Thank
get
you,
to the
Judge.
summary judgment now. And
Okay.
anything you want to add? It's your.
Yeah, there are quite a few things there, I guess, Judge, and I do appreciate your time. This is obviously personal to me. It's about me. There are a lot of attorneys, I think most of us really care about our reputations, really care about what the public thinks about us. It really does matter. You work your whole life, you try to build up a business. I have great contractors and people that work with me. My son is here with me. I have George Boyer with me and Scott Caterer. All of these gentlemen and their families are affected by what's said and what this is. And so it's very personal to me, and it's very concerning. So with regard to the summary judgment, with regard to knowing exactly how difficult the standard is, I did cite in my brief the Twombly case, which is a federal case. And I know that that's a case that's designed towards motions to dismiss. And it is actually a higher standard, but you have to have a plausible explanation when you go to defend against a motion to dismiss, or when you go to defend against a motion for summary judgment. The federal court standard is set that as the plausibility of a claim or defense. And what we have here with regard to the defenses is that Mr. Franklin admitted in court that he did the publication and that he's the originator of it. As far as the technicality part of putting it on the web and putting it on air. And he's admitted to all that. And he's also stated that he had this unknown phantom of a customer who provided him with the content. And all he has to do is say who that person is. But he won't. And he refuses to. And he's conjured up this implausible explanation where he states that this person came to him, didn't pay him anything, gave him this defamatory content about myself and my family and my friends and others who depend upon my business, and that he just puts it online, publishes it, without even reading it or even looking at it whatsoever. And thereafter he says, well, this phantom didn't pay me, but I paid for it on my own credit card. And I did it through domains by proxy because I wanted to shield my identity. I wanted to hide who I am. Because when you do talk about First Amendment cases, you don't try to shield and hide who you are. You know, you can say what you want to say, but not in this case. He goes through domains by proxy. He buys that with his own money, puts it on his own credit card, and then he publishes it. And then he says, the phantom never paid me. And so I just took it off the air. Well, what had really happened, in addition to that, was he also went online onto Google, and he misrepresented who he was on Google. And he said that he was the owner of my business. And when he said he was the owner of my business, there is a little website box there on your Google landing page that's on the web. And he redirected that page to his page. And so all of my old traffic that had been going to my other website, my legitimate website. All that traffic was redirected to this other website, which I have termed a manifesto, probably a poor choice of words, but obviously very sensitive to me.
Pretty much like one.
And just this,
It's a fair word.
okay, thank you, Judge. Just this rant against me and mine, my family, my people,
Yeah.
and just on and on about all these untrue lies, false statements, thieves, stealing money, just essentially extracting from desperate people, not providing services, not doing all kinds of things that right to the core of our business, right to the core of what we do. And so he redirects all that traffic. And my son says, hey, phone's not ringing. Something's going on here. You know, business has just stopped. So he goes online, he investigates, and you've seen his affidavit, and he's here and he can testify to it. And he sees this. And so immediately we file as quickly as we can, because it's created a hardship on us. It's created economic damage. It's created trouble. And we get that file. We attempt to serve Mr. Del Casal. And right about the time we attempt to serve him, because he's evading service for quite some time, it goes off the air. Just coincidentally, it's off the air now. And so we know, and based upon the language that's contained in the manifesto, there's only one person that knows that information. And we are all testify that only Ernest Del Casal knows that information. He's the one, he is the author, and he says, I don't know anything about the publication, and I don't know anything about who did it. But come to find out, he and Michael Franklin are old friends. And actually Michael Franklin has been his web designer and has helped him with all of his online. And we knew that he had to have help all along, we just didn't know who did it. We didn't know who would be crafty enough to change that Google page or to lie and say that you were the owner of that business and have that redirected, the legitimate traffic over to your illegitimate website. The website that allegedly they sold to me, which really wasn't so much about the breach of contract as it is, hey, where you redirected that was property that you should have gave to me. And so you've done everything to try and harm my business. And so here we are. And they've not produced one shred of evidence to withstand the summary judgment in this. In discovery, not one document has been produced. Nothing. Not one single solitary piece of paper of any independence that we could look at and evaluate. Nothing. Nothing whatsoever. I have nothing, I have nothing, I have nothing. Just complete denials. And on Mr. Franklin's part, he's completely admitted his whole role in this. And so with regard to the summary judgment motion, I have several causes of action, and I appreciate your honor pointing your finger, and I'll try to be brief. But it looks as though there is a conspiracy. These are two or more individuals that have conspired together to do this, what they have done. And I believe that summary judgment can be granted based upon the conspiracy. They know each other, they've known each other. There's nobody else that would know this information, on top of the fact there's no one else with any motive who would ever want to do this, as far as we know. And we certainly can't find them. But Mr. Franklin could solve the problem by saying, disclosing the phantom, which in discovery I asked him who it is, and he won't say. He's not going to say. And so I guess he's going to keep that to himself.
All right, let me sort of interrupt you respectfully on that, because since you're talking about civil conspiracy, maybe we will talk about the various causes of action. That requires a combination of two or more persons by some concerted action with intent to accomplish some unlawful objective for the purpose of harming another. And if you look at the case law in that area, it centers on this idea of what we call in criminal law, not civil, but scienter, this idea of intent. The civil cases talk about it as a state of mind issue, which is usually inappropriate for summary judgment, but the law says unless the non-movement, that would be these on this side of the room, fail to produce requisite quantum of evidence to prove otherwise. But it's that state of mind issue that becomes a little bit of a nebulous concept, because in order to have civil conspiracy, you have to prove what each of the defendants alleged to be in a conspiracy had in their mind in their activities. And that's a little more difficult probably, because anytime you try to prove something that somebody's thinking and what their intent was, well, oftentimes that's going to be mostly circumstantial evidence, which can be powerful, I get it. but that is a bit of a problem here, especially in light of this issue, which you've talked about now a few times, this, you know, phantom individual, and what have you. But, you know, I just thought I'd mention that. I don't know if you want to say something, given that, again, we're talking about a civil cause of action that requires a mental state of mind element.
And my focal point on the state of mind is this domains by proxy. For me, that makes the case in summary judgment. Domains by proxy, that's my state of mind. I know that I'm up to no good, and I want to hide, and I want to shield my identity, and that's why I'm using this service out of Phoenix, or wherever they're located down there in Arizona. That's why I'm using this service, because I want to shield who I am. And I know that I'm up to no good, and that's why you use them. And I did attach the who is, and you can see that when you go on who is on the website, it points you to domains by proxy, and they try to put you down the rabbit hole. And but we did send them the subpoena, and we got the information, and we know exactly who the owner is. But they did try to shield that, and that would be my only point towards that, Your Honor, and thank you for the opportunity to readdress that.
Okay.
With regard to the other cause of action with the breach of contract, the contract specifically calls that website is to be turned over to me. It never was. I think their defense is I never asked. It never was. And whether or not I ever asked or not, they certainly doesn't give them the right to use it. It doesn't give them the right to use what you sold to another. And they clearly knew that, and they clearly knew what they were doing at the time. And so they breached that contract with regard to the actual website. We also have the corporate theft, which I point to the website that are the cause of action 2 and 4. I think 6 cause of action, the intentional interference and business disparagement, is quite clear on its face.
Well, let's talk about the business disparagement separate from the theft. And the reason I'd like to do that is because there's a malice requirement for intentional interference with business or business disparagement. That's element 4.
Okay.
That's a different style element, because that malice element would be intent to cause harm or basically reckless disregard to cause harm. It's a malice argument where you don't have the malice and the theft elements.
I understood,
So
all right.
That does differentiate them, I think so.
With regard to the theft, there are 2 aspects there. One is part of the breach of contract, that they've stole my property, which is the web name, the web address, the web page, or whatever it is. Whether or not I ever intended to use it or not, I think is irrelevant. I never did intend to use it. I think that it had a really bad past that I was hoping to move forward on and maybe not be quite so negative. And I was hoping maybe I could just kind of put that to rest by owning it and just letting it go its way and never to be used. But they've taken that, and they've used it. In addition to that, they've attempted to steal business by redirecting the Google page from my legitimate website over to their illegitimate website that they set up. They were attempting to steal customers, steal clients, and Mr. Del Casal styles himself as a competitor with the attorneys. I'm not sure what he means, but he helps to prepare documents according to him. And he has a competing website, I guess. And so they were trying to redirect my clientele away from me and potential customers over to them. And I believe that it makes the case on summary judgment with regard to the theft aspect of that. And that they took things that essentially just were not theirs or attempted to.
There's a sort of recurring theme, given that there's 2 defendants here, that has to be, I think, further developed right now. So on the breach of contract, is that something that you're even including Mr. Franklin in, or just Mr. Del Casal?
Just Mr. Del Casal.
Okay, I thought so. And then the theft, corporate theft, is that the same situation, just Mr. Del Casal, or do you have an argument that brings Mr. Franklin into that?
I think it's Mr. Del Casal who's directed Mr. Franklin to do these things. I just don't think that Mr. Del Casal knew how to change that Google listing over. Quite frankly, Your Honor, I don't know how to do it. I wouldn't know how to do it honestly. Maybe dishonestly I could figure it out, but I couldn't do it honestly.
Okay. All right, so do you want to say something about the business disparagement and/or the defamation cause of action.
Certainly, Your Honor. And I think I'll just touch on that very lightly. Your Honor has touched on it, and I do believe that the publication speaks for itself and that it is defamatory. It is libel, and it is an unprivileged communication. It is published to the world, published to third parties, and the intention there is to do harm. There's no intention there that serves the public, and there's no intention that does anything other than to run my business down and to harm me personally as well as others.
Let me ask you a question. Do you think you're a public figure?
No, sir.
Did you run for office?
I did at one point, Your Honor, yes, 2008 and 2012. Thank you, Your Honor.
All right.
What they've done essentially is they took my legitimate web traffic, or at least anticipated web traffic, and they brought it over into their domain to disparage me and to disparage my business. And it was a concerted effort between the two of them acting together to set up this artifice and able to take legitimate customers or legitimate potential customers and to have them go over to read this negative thing about me, and thereafter attempt to republish and to try and broaden their scope of publication, all in an effort to do harm. When you read it, there's no effort there to help, and there's no effort that benefits anyone. It's just all ranting and false statements, lies, about business practices which are fabricated solely by Mr. Del Casal. But these two had to work in concert. They had to act in concert to set that up in order to disparage the business and in order to do harm to the business. With that being the case, Your Honor, I think that essentially the defamation per se, I think, speaks for itself, and it is directed completely towards a business. I know Mr. Franklin indicated in his opposition that I haven't stated any damages. I don't have to. That's not the requirement with a defamation per se allegation. I think it very much meets all four corners of the elements of defamation per se. We'd ask for summary judgment on that. And Your Honor, thank you very much for your time.
Before I turn it over to Mr. Needham and Mr. Franklin, let me ask you, what's the current status of things relevant here? In other words, you mentioned that the website that you characterize as a manifesto was taken off the air. And then you talked, of course, about this redirection concern. Is any of that going on for a while, or anything still going on?
All that is remedied, Judge, thank you. And that was actually remedied at the time of the first hearing, March 5th. Everything has been status quo since that time, to my knowledge. The only thing that's gone on is Mr. Franklin has gone out and said that I extort, has made some publications on a new webpage that he's launched, saying that I extort money and file frivolous lawsuits, and I think he accused our staff of being racist, that we're all racist. Those are his latest publications. That was since July of 2019. He's gone to that, and Mr. Del Casal has kind of supported him by clicking thumb up or whatever on the web pages. So they continue to work together, but as far as my business, all that is remedied, Judge. Thank you.
I said that because I know that there's this stipulation going to come our way, but, you know, I wanted to check and see whether any sort of restraining order was necessary. But I'm glad to see that the status quo was met. Other than what you've mentioned, that's not part of the case that I know of yet. You'd have to potentially bring that in if you wanted to.
Yes, sir.
Okay.
An absolute decree of divorce is granted.
By September 6th, you will pay $6,000 of what is due.
I make a finding that paternity has been established.
He was a potential danger to his children.
We're here for the court's order to show cause. Okay, so that takes care of one motion.
We will make sure that she's put on house arrest.
As you know, the Supreme Court has
Well, Mr. Needham.
I'll be brief, Your Honor, more brief than this one. In our opposition, and we also filed a counter motion for summary judgment, and I'll try to brief and state the reasons why.
Okay.
When Mr. Harris first brought his lawsuit, the original complaint, it was just against Mr. Casal. And there was some does, and he didn't know who created the website. And when I say website, I'm talking about two websites. There's the original website that was in the contract that was supposedly sold by way of the contract, and then there's this second website, which is the one that's been labeled as a manifesto. And that's an important distinction because Mr. Casal has said from day one, he didn't have the password of this website. When you he sought out services, it wasn't Mr. Franklin, some other website designer to create this website. That person has the password, and in fact, at the bottom of the website, apparently, that's the contact information of this website designer. Mr. Harris had that information, so if he wanted the password to that original website, he could have called the guy. Mr. Del Casal didn't have that password. He didn't create a website on the old website. And then Mr. Harris subsequently abandoned it. And I think what happened is, as we all know, when domains, at some point they expire. And that's when the same domain was then evidently, the evidence shows, was purchased by Mr. Franklin. So now creating the second website. So in regard to the theft claims, there's two of them, the corporate and basically I think it's more of a conversion, not so much theft. They can't be proven because Mr. Del Casal didn't have the password to begin with, and it was subsequently abandoned. So there's summary judgment to be entered right now today, forthwith, in favor of Mr. Casal on the theft claims. It doesn't make sense based on the evidence. In regard to when Mr. Harris did discover Mr. Franklin was behind or purchased the domain name that was expired, and behind the website, they added him to the lawsuit. Mr. Casal has said from day one that he is not part of this that's a big deal, by the way, Your Honor. The element there it's a huge deal. That shows right there, and it's not disputed, that Mr. Casal doesn't own the domain name, doesn't own the website in question here, and didn't build it, didn't publish it. So so we go on to discovery, and I asked Mr. And by the way, we've done 2 declarations on this case, and we've submitted them on the record where Mr. Casal has said all this. He's responded to every single claim that the plaintiffs brought against him, saying, I wasn't involved, I don't have a password, I didn't create the website, don't own it. We go on to discovery, and as my opposition lays out, we ask Mr. Harris for anything he's got. Any evidence he has whatsoever that Mr. Casal is involved in this. He has nothing. So that was over and over and over. He didn't produce a single piece, any documents to link Mr. Casal to this website. So therefore, we asked for, we brought a counter motion for summary judgment based on the evidence, which is the declarations of Mr. Casal, the documentation that shows Mr. Franklin owns the website and the domain there too. We asked for summary judgment in our favor. And we said on the final request for the court was, since Mr. Franklin purchased the domain name and that was abandoned by Mr. Harris, and Mr. Casal didn't create the website, therefore he couldn't publish it. That's a key factor on defamation. He shouldn't be liable in this case, he should be dropped. This is really a case between Mr. Harris and Mr. Franklin. In regard to the redirecting in Google, it's my understanding that when you own a domain name and you have a website, you have the power to go to Google and say, register it. So I don't think there's any redirection. I think it's just an automatic right to have for any website owner. So I don't think there's any hijacking or anything like that there. That's just a standard part of owning a website. And that'll conclude my argument, Your Honor.
All right,
Thank you.
thanks a lot, Mr. Needham.
Your Honor, I did have a few points, I'm sorry, to address. You mentioned that the defendants blame each other. I don't see that here. Mr. Franklin has never blamed Mr. Casal. I wanted to address that point.
Okay, maybe that's not the best word.
Yeah, I just wanted to address it.
Hold on a second. The best word from the dictionary for me to use. But the full upshot of one defendant saying it was not me, and the other defendant basically saying the same thing, it looks like that's what's going on here, but I understand.
Okay.
It's not an affirmative blaming of each other, but it's, I didn't do it. The other person, for example, you've said in court today and in your pleadings, it was Mr. Franklin that controlled the website and your client didn't have anything to do with it. So that's one way of saying, I think, you're blaming Mr. Franklin for the website. That's just my word for that.
I'm not really blaming Mr. Franklin. I'm just saying the evidence shows
Okay,
that
fair enough.
I guess the domains by proxy information shows it. And also I think Mr. Franklin's admitted it. So it's not like I'm blaming him.
Okay.
In regard to Mr. Harris's comment that Mr. Casal and Michael Franklin are friends, I'm not sure if that's the case. In fact, some of the papers indicate that Michael Franklin knows Mr. Harrison and received services from Mr. Harris in the past, as far as I know. So they know each other, Mr. Franklin and Mr. Harris. So in the other point, Mr. Harris kept saying they and their, like they're working together. Again, I don't see the evidence combining the two. So I would like to distinguish that, there's no evidence of conspiracy that I see. Thank you.
All right, and Mr. Franklin.
A lot of this, when you buy there were several things that I wanted to find out. No, Ernest did not have anything to do with this. I was given the information by a client. I don't think that I should have to, if he's putting all the blame on Ernest, I don't think that I should have the burden to prove his case or try to help him find who did it. That's what discovery is for. So, no, he didn't have anything to do with this. I was given the information, and to buy a domain name is only $14.99 for an entire year. That's nothing out of my pocket usually when I purchase domain names for people, because I do it all the time. I purchase domain names for several clients, and then I've gotten paid for the domain name, and I've gotten paid for building the website. My job is a service industry. I get paid for the services I do. So
you're a website guy.
I'm a website designer. So I design the website, and then I get paid for designing the website. The information was given to me, and then even in the documents, I showed that how I purchased the domain name through GoDaddy. I allowed the domain name to be sent back into GoDaddy. I allowed the domain name to expire. The domain name was still not purchased by Kurt. So, and all that is in the previous documentation.
Now, who's responsible for everything on that website?
Excuse me?
Who's responsible for everything on the website, the one that's been taken down? I'm glad it's been taken down, actually. Well, who's responsible for the content on there?
Well, I was given some paperwork from a previous client.
All right.
He wanted to remain anonymous.
Okay, I understand.
He wanted to remain anonymous, so I wanted to respect his wishes, and I don't ask a lot of questions. I did read the information. I also wonder where the information came from. I did read it, but I've also heard a lot of things about equal rights for divorced fathers, especially after the purchase of equal rights for divorced fathers. So I've heard information from different people in Las Vegas.
All right, let me ask you a question. And this is not, please know, this is not a criticism of you not having a lawyer. You're certainly welcome. We have plenty of people come in and do good jobs, actually, without having a lawyer. But there's something in this that I just want to at least throw your direction for your consideration. There is an area of law that talks about those that set up websites and what responsibility they have under the law for setting up websites.
Okay.
And it's something worth looking at here, I think. And it could be, you can probably figure that out on your own, but it could be that counsel that knows about that area of law can help you. I don't know. But if you want to get a lawyer, certainly you could. But I just want to at least mention that to you.
Well, I would like an opportunity to get a lawyer as well, but also to do discovery because from
Okay,
what
I
I
can
understand.
interrupt you on that point. When people come into a courtroom, at least in this one, and they say they want to get a lawyer, I support that, and I'd like to give you that opportunity to now participate in the case. So if you want to do that, I'd give you a couple of weeks, and you could even have counsel weigh in on what's going on here now, if you wanted to, as far as I'm concerned.
Okay, I think that's great. My insurance, well, that's a good thing because my benefits on my job just offered me a program, and this just happened yesterday.
Okay, so this sounds
So-
good, because if you get a lawyer, I think it'd be helpful to the situation.
Okay.
I do. Okay. Because again, there's another part of the law having to do with website creators. It's area of law has to do with creating websites as opposed to putting the content on websites and what have you. It's something we're looking at here. I think it's relevant to the mix. Okay, to look at that. All right, you want to add anything else for today?
Yeah, well, just that I did not write the content. The content was given to me. I did not. So, and then as far as the theft of the Google listing, there is no way to steal or hijack the Google listing. You would have to, in order to have a Google listing, they will mail a letter out to your office, and you have to put a code into the Google listing in order to claim the listing. The issue is, at the time when I was given the information, I already owned the Google listing. It was from way back when I first started dealing with, I created the Google listing. So there was no theft of a Google listing or a hijacking of a Google listing. You cannot do that, it's impossible.
All right, Mr. Franklin, it could be that when I enter a court order on this, I put something in there about 2 weeks to get a lawyer.
Okay.
Do you think that's fair, to give you that opportunity? I'm not ordering you to get a lawyer, but I'm saying if you're going to do that
Yes,
for a couple of weeks.
please allow me a couple of weeks to get.
All right, Mr. Harris, you get the last word here today.
I'll be brief, Judge. I know the last time we were here in July, Mr. Franklin said, and Your Honor told him you should get an attorney, and he said, well, I think I'd like to. And so here we are 5 months later, and he's,
I recall saying that, but I
Thanks,
usually
Eli.
give people that option.
it was good advice at the time, and it's good advice now. Just a couple of things. The website, Mr. Needham's indicated I've not provided any evidence whatsoever. The website in itself is the evidence. It's written in a first-party language, third-party, first-party. You can tell, you know that it's written first-party. It's pretty easy to figure out. So the evidence really does kind of testify against Mr. Del Casal. Second of all, I did, with regrets, I guess, I attached the bar complaint that he filed against me as well. And the language mirrors. The topics are the same. the grammatical errors are the same. When you look at the two together, one is much more expanded, but you know the author is the same, and so there is proof. And it's pretty conclusive proof that Mr. Del Casal is the author of the content. Thank you, Judge.
All right, I'm going to do a written amendment order within about a week from today on this whole thing. And just a friendly reminder, Mr. Franklin, you're going to see in there, I'm going to, again, mention this idea of the lawyer and give you a couple weeks of the time to sign the order, okay? So we'll see how that all goes, but I appreciate the briefing and the argument. Again, a written order to be published within a week from today.
Thank you so much, Your Honor.
I think we're back here at 11 on the calendar.
Calendar call, yes.
Yeah, counters all that.